Oh, good afternoon, everyone. One moment, I'm going to turn up my lights. There we go. Good, I think we're Zoom ready now. So thank you for joining. I'm Michael Ettinger from Ettinger Law Firm. This is the second in our six-part series of Zoom side chats. I'm glad you could join us. For those of you who haven't been with us before, I'm the principal of Ettinger Law Firm, practice limited to elder law estate planning. And this is the second of a six-part series. Today, we're going to be talking about protecting your home and life savings with a Medicaid Asset Protection Trust. For those of you who are new to this session, there's a Q&A portion at the bottom of your screen. We have a lively question and answer session at the end. So type in all your questions. And while I can't take them during the presentation, I'll certainly be happy to answer them at the end. Ettinger Law Firm is a statewide firm. I'm going to actually go ahead and share the screen with you so you can follow along with me. We're a statewide firm. Our practice there is limited to trust and estates, wills and probate, tax saving strategies, Medicaid. Basically, elder law estate planning is all we do, all we've been doing for more than 30 years. We have 5 offices across Long Island, 2 in New York City, Brooklyn, Staten Island. We have offices in Westchester, Rockland, and in the Hudson Valley, Orange, and Dutchess counties, and up in the Capital District, Albany and Saratoga. This is our esteemed staff. I'm there in the middle. Facing your screen to the left of me is my lovely wife and partner, Suzanne Ettinger. You will get a copy of this broadcast, so if you find it useful, you're free to send it, welcome, in fact, to send it to your friends and family who you think might benefit by it. So with that being said, let's go ahead and start with the Zoom side chat. Protect your home and life savings with a Medicaid Asset Protection Trust, MAPT for short. So let's have an overview. Not everybody even knows what a trust is. So if we're talking about Medicaid Asset Protection Trust, first we want to talk about what a trust is. And a trust is a legal entity that allows you to separate the use and enjoyment of property from the bare ownership. In other words, the trust can own it and somebody else can have the use and enjoyment of it. We also have this feature if you do a deed with a life estate, you deed the property to your son or daughter, reserve the right to live there, you have life rights. So you have the use and enjoyment, they have the bare ownership. You'll see why this is important in a moment. So you take assets you want to protect, like your house, and maybe money that you're, not living on, but you're just keeping for safekeeping, and you retitle those into the name of the trust. Now, what you've done is you separated the use and enjoyment from the ownership. You can keep the use and enjoyment under the trust, but the trust is now the owner. And you not being the owner, then if you need care, those assets don't count as belonging to you. So as the trust beneficiary of the use and enjoyment of the trust property, the bare ownership resides with the trust, which is separate from you, has its own social security number known as a TTID, Trust Tax Identification Number. So there's our overview of trusts. And the trust is in fact, well, I'll get to that in a moment, but if something happens to you personally, like a nursing home, they can't get the assets because you don't own it. So not that hard to understand. And this is why the trust has been called the greatest invention of the English common law. Trusts have been around since the 1100s. Well, many of you have heard of the 5-year look back for nursing home care. So let's go into that a little bit. Medicaid can look back up to 5 years. What does that mean? Well, it means if you transfer an asset and you need care within 5 years, Medicaid can go back and ask you to contribute that asset. In other words, it's not protected because they have a 5-year look back. And the reason for this is if they didn't have the look back, everybody would just wait until the day they have to go into the facility, transfer everything the day before, and then say, take me, I'm here, I don't have anything. But it's not an all or nothing rule. Let's say you transfer your house 4 years later, you have to go into a nursing home. At that point, you only have to pay for the 1 year that's left. And the reason is, when I apply for Medicaid, they're going to ask me, what did you take out of your name and transfer to someone else or to a trust? What did you take out of your name? What did you transfer? What did you give away? Now, let's say you gave away the house 4 years ago to the trust. We don't apply for Medicaid because we're not eligible. If we apply for Medicaid, they're going to say, give us the house back. So we don't apply. What we do is we private pay for the 1 year that's left, then we apply for Medicaid. Because the question on the Medicaid application is this: what have you transferred within the last 5 years? Unless you can say nothing, you're not eligible, so we don't even apply. Why apply for something you're not eligible for? We wait till we get past the 5 years. When we can answer that question, we haven't transferred anything within the last 5 years, because it was 5 years and 1 day ago, and then you're eligible for Medicaid benefits. So you have to pay for the time that's left. So if you transit the house 3 years ago, and now you have to go into nursing home, you have to pay for the 2 years that are left. Let me go back. This is why the Medicaid trust is useful, even if you have if you're very elderly or you have a health problem, you're not sure if you can get the 5 years, it doesn't matter. It always pays to get started because you get the benefit of the time. We know that there's coming a new 2.5-year look back for home care. The current look back is 1 month. It was supposed to be on October 1. They were going to change it to 2.5 years, but they postponed it for 6 months due to COVID. So now on April 1 of 2021, oops, you see we didn't update the slide there. As of October 1, so it's actually April 1, 2021. It got a 6-month reprieve. The new look back is 30 months. And they're phasing it in by adding 1 month each month until 2023. So let's say you need home care today. You move all your assets out of your name. On February 1st, you're eligible because there's no look back. Starting October 1, they're going to phase in the 2.5-year look back, 30 months actually, which is 2.5 years. By doing this on April, if you apply in May, there's a 1 month look back. If you apply in June, there's a 2 month look back. July, there's a 3 month look back. They're going to keep adding a month for the next 30 months, and we get to the end of 2023 now. 30 months after the middle of this year, it'll be go forward forever as a 2.5-year look back. And this makes the Medicaid Asset Protection Trust an essential tool for those who want to age in place. If you want to be able to stay in your own home and you don't want to have to use up all your money for your care, you're going to have that trust 2.5 years ahead of time. Otherwise, all your money is in play. And without the MAPT, many people will be unable to afford care at home. They'll be forced to sell their home and use the money to pay for assisted living. So this trust is actually going to help you afford to be able to stay in your own home. And the money will be available for your care if you need it. And we want home care. We don't want the spouse to be the caregiver. You know, we meet too many spouses that wear themselves out. And in fact, many spouses die before the ill person because of the stress of caring for somebody 24/7, 365. It's a hard job, and generally the spouse is elderly themselves, so something we want to avoid. So why set up a Medicaid Asset Protection Trust? Well, it avoids probate on death like all trusts. As some of you know, every Wednesday at 2 o'clock, tomorrow at 2 o'clock, I give a full-blown elder law estate planning seminar. I talk about revocable versus irrevocable trusts. I talk about inheritance protection trust to keep it in the blood. I talk about the Medicaid Asset Protection Trust and a few other things, elder law power of attorney. So if you want the whole scoop on elder law estate planning, tune in tomorrow. You sign up, you register at ettingerplan.com. Just go to ettingerplan.com and you'll be able to sign up for that seminar tomorrow too. And even if you can't make it, if you sign up, they send you the recording. So with the trust, we avoid probate like all trusts, revocable, irrevocable. So even if you never have to go into a nursing home, it still saves you more than it costs because these probate proceedings easily reach the tens of thousands of dollars. Now, what are your other options? Some people think, well, what if I put my son or daughter's name on the investment account or on the deed? This actually doesn't work. Medicaid has a rule, and the rule is that on jointly held assets, it's all considered belonging to the ill person, except to the extent the other person can prove the amount of their actual contribution. So just by putting your son or daughter's name on the bank account, the joint doesn't make it half theirs. For Medicaid, it's all yours unless you can prove they put money in, which most of the cases, of course, they didn't. You just put their name on, so it offers no protection. Again, the rule, Medicaid considers the jointly held assets as all belonging to the ill person, except to the extent the other person, the other joint owner, can prove the amount of their actual contribution. What about transferring, putting everything in the kids' names? Well, people think, I'll put my house in my son or daughter's name to protect it. But now, all of a sudden, your house is caught up if they have a financial problem, if they get sued, if they get divorced, if they're in an accident, et cetera, cause of personal injury. So this is adding to your exposure, your legal liability. There are tax reasons not to do this. Maybe we'll get to that later. If not, I'll come back to it. What if they spend it? If you give them the money, they spend it, or they don't give it back when you need it. These things happen. What if they die before you? It ends up going to their heirs. So before we go on, there's also a tax problem. When you pass something by inheritance, the children get it at a new basis. The basis is what we use to calculate the capital gains. So for example, let's say you bought a house for $250,000, and when you die, it's worth $500,000. Your heirs get it as if they paid $500,000. They get it at date of death for capital gains purposes. It gets reevaluated. It's worth $500. When you die, they get it as if they paid $500. Now they sell it. They paid $500. They sell it for $500. There's no gain, no capital gains tax. In other words, death wipes out the capital gains tax. If you give that house to your children while you're living, they didn't get it by inheritance. So when they go to sell it, the basis is what you paid, $250. They sell it for $500. They have a gain of $250,000, and the tax on that is about $75,000. So you want to avoid that problem. So the other pitfalls, you can't transfer the assets to your spouse to protect them, because the combined assets of the spouses are available for the care of the ill spouse, regardless whose name they're in. In other words, Medicaid considers husband and wife one person, one unit. Now, the Medicaid trust is an income-only trust. So you limit your access to the principal by naming somebody other than you or your spouse as the trustee. The trustee is the manager of the trust. And if you're the manager, you can take the money out. And if you have to go into nursing home, they'll say, well, if you can get it, take it out and give it to us. If you could get it, they could get it. So you have to pick somebody else. People almost always choose one or more of the adult children as the trustee. And what does this mean? Well, you still own the trust and you're still the beneficiary. You still have the exclusive use and enjoyment of those assets, but they're the manager. They act like a figurehead for you. Because again, if you can get it, they can get it. So now you put assets in, and it's an income-only trust. Why is it an income-only trust? Because if you can get principal, the nursing home can get it. So it's income-only. You put in stocks, you only get the dividends. You put in CDs, you only get the interest. Now, why would you do something like that? Well, people have a lot of assets they're not spending, like your house. Doesn't matter to you if your house is in a trust or not, revocable, irrevocable, makes no difference. You still have the right to live there. You pay the taxes, you mow the lawn, same as before. But let's say you have a nest egg. I like to use this example. Let's say I have a nest egg, $500,000. It's not IRA money because, as we'll learn, IRA, 401k, 403b are all exempt from Medicaid. I'm not worried about your retirement accounts. But many, many people come in and they say they'll have a nest egg, let's say $500,000. It's not IRA money, which is available for the cost of your care. A lot of clients say, well, we're not spending that $500,000. We're just, we actually don't need it. We have enough income. Some other clients will come in and say, we're not spending the $500,000, but we're taking the interest or dividends. We need that to live on. Well, fine, the trust gives you the interest or dividends. But you realize if you have a nest egg that you don't need to live on, you're actually safe keeping it for the nursing home industry. What do you think happens? Client gets to 88, 89, has to go into nursing home. Over the business office at the nursing home, they're jumping up and down because they see that 500,000, and that means your private pay. In any given facility in New York, about 3/4 of those residents are on Medicaid. Is Medicaid paying the nursing home, say, 18,000 a month? Of course not. Are you getting the same care as everybody else? Well, sure. So no wonder they're happy. They just hit a home run with your money, and it's totally unnecessary. For more than 30 years, you've had to take that money, put into the trust, still there if you need it, but somebody else can't come and take it away from you. We're going to get into this a little more deeply now. So it doesn't affect your lifestyle. You still get your pension, your Social Security, your interest, your dividends, the required minimum distributions on your retirement accounts. You keep all your income. You have the exclusive right to use and enjoy the primary residence. You keep all your exemptions, senior, veteran, star. Let's say you have an investment account and you put in the trust. Can you continue to run it? Yes. The trustee, which is your son and daughter, when the account gets moved into the trust, they sign something called a third-party authorization saying, I authorize mom and dad to trade on the account, and you run it the same as before. If it's online, they take out the PIN, the personal identification number, they give you the PIN, and you can log in with the PIN. Now, you're not giving up control with this trust. We don't give up control because, you could have a falling out with the trustee, or you don't agree with the way they're handling it, or they run into some sort of problem that's distracting them from handling your affairs. You reserve the right to change the trustee at any time. So they're in charge of the trust, but you're in charge of them. So you still have control. More benefits. You can sell the house and buy a condo. A lot of people think it's an irrevocable trust. You can't sell the house. I don't know where they get that from. We've done it, thousands of times. So the trust sells the house. The money is paid to the trust. And the trust goes and buys the condo in the name of the trust. It's all internal. It doesn't start to look back. The trust can buy, sell, and trade stock. IRAs and other qualified plans exempt from Medicaid. So they're not put into the Medicaid trust. Now, you do have to take your required minimum distribution. That's income. And Medicaid gets that because you have to take it out, and it's income. They get income, but they can't get the asset. Let's say you want to sell your house. Some of you know that if you sell your house, your primary residence, if you're a couple, you can exclude up to $500,000 of capital gains taxes. If you're a single person, you can exclude up to $250,000 in capital gains taxes. When you put in the trust, you keep this exclusion. The trust is designed for tax purposes to preserve the exclusion on capital gains taxes on the sale of the primary residence. Now, here's a shocker. In New York, you can revoke an irrevocable trust. People are very surprised to find this out, and we're going to look at why. It's called an irrevocable trust because you, the grantors, the people set up, you can't revoke it yourself. So law says, so far as you're concerned, that's an irrevocable trust. For those of you who may have joined us late, there's a question and answer button at the bottom of your screen. You can go down, type in your question, and we'll answer all the questions at the end. So you can't revoke it yourself. It's in a revocable trust, the grantors, mom and dad, or if you're single, mom or dad, you can't revoke. In a revocable trust, you can undo it yourself. Here, you can't undo it yourself, so it's considered an irrevocable trust. But New York has another rule on the books that says if all the parties named in an irrevocable trust agree in writing that they no longer want the trust, you may revoke it on consent of all the named parties. Well, who are all named parties? You and your children, right? If everybody signs, you can undo it. Now, what if one of them won't sign? Not a problem. We amend the trust, we take their name out of it, and then we revoke it on consent of the named parties. So we can always undo it, even if we have a little opposition. Okay, so there's the workaround. If one won't sign, we fire them as trustee, or we take them out as one of the heirs, and they don't have to sign anymore, and you undo it. Let's look at the Medicaid Asset Protection Trust versus the life estate deed. I talked about the life estate deed earlier. It's where you deed your property to the kids, you reserve the right to live there. One of the drawbacks is when you deed it to the kids, if you sell the house before death, the life estate value goes to the nursing home. They say the life estate is worth about half the value of the house. So, they may need or want to sell the house. And if they do, half the value will still go to the nursing home because they still have an interest in it. If the house is rented, the net rents go to the nursing home because the life tenant is in, mom and dad are entitled to the rents. If the house is sold during the lifetime, remember I said a couple can exclude 500,000 of gain and 250,000 for a single. Well, most of that is lost if you deeded the house to the kids because you're not your primary residence. They give you something for the life estate, but only a fraction. And so the big drawback is they can end up carrying a vacant home for years because if they rent it, the rents go to the nursing home. If they sell it, they pay the capital gains tax. If they sell it, you also have to pay the life estate value of the nursing home. So why do people do a life estate deed? Well, generally, they don't go to an elder law attorney who knows how to prepare a trust because you have none of these drawbacks with the trust. But they go to a general lawyer. Now, every lawyer knows how to prepare a deed. So the lawyer does a deed and doesn't know because they're not elder law attorneys. They don't know, or not tax attorneys like we are. They don't know all these drawbacks. It's not their field. They're just real estate lawyers. They know what they know. So how do you keep control with the MAPT? Well, we already said you can change the trustee, but you can buy and sell assets, keep your property exemptions, can change the trustee at any time, can change who you leave it to. So, I'm so disappointed sometimes. I have to review a lot of these irrevocable trusts because people come in with them, they want my opinion. And I'm amazed that the provisions that we have in our trust are not in every trust. But, we've been at it for a long time. We've probably done, well, not probably, I'm quite certain we've done more of these than any other firm in New York. Certainly over 25,000 of these trusts now, but when you've done enough of them, you cover every base. And so all the bases have to be covered. And the main one is that I see the mistake that sometimes lawyers make. They don't let people change who the heirs are, or they don't let them change the trustees, or they don't allow them to make gifts. You need flexibility. You can't write a trust and not be able to change who you leave it to. You can set up the Medicaid Asset Protection Trust. It's an irrevocable trust, but you can reserve the right to change the heirs. Have to have that. Things change. And you also have to have a way to get your money out. And this is also missing from some maybe less experienced attorneys who try this. You have to be able to get money out. For example, let's say we set up the Medicaid trust. 4 years later, mom has to go into a nursing home. And remember, we have to pay for the 1 year that's left, but where are we going to get the money? It might cost $125,000 more, $200,000. Where do we get it? Well, you can make a gift of the principal through the gifting power. So when you set up the trust, you can take out principal, but you can reserve the right to give the principal to somebody else. In other words, you can reserve a gifting power. I reserve for myself the right to make gifts of principal to any of my children. So now you set up the trust. 4 years later, you have to go into a nursing home. You make a gift of the $100,000 you need because you still have your income. So you might need, let's say, $150,000. You can gift that to your daughters or sons tax-free from the trust. They use that money to pay for your care until you get past the 5 years, and then we apply for Medicaid. It's for home care. They lend you the money until you can get past the 2.5 years, and then we apply for home care. And the reason for this is when I applied for Medicaid, they're going to ask me, what did you take out of your name and put into the trust? But they're not allowed to ask me what the trust gave to somebody else. So you make a gift from the trust to your son or daughter. They can't give it back to you, but they can spend it on you. The reason they can't give it back to you, because when I applied for Medicaid, I have to show them all your investment accounts, all your bank accounts for the last 5 years. If they see that 100 or 150,000 came in, they're going to say, where did that come from? And if it came from the trust, you're sunk. So they can't give it back to you, but they can spend it on you. Their money, they can do whatever they want. And as I said, it's very flexible. You have control because you can revoke it on consent of all named parties. And as we said, one of them doesn't agree, we take their name out and revoke it with the consent of the other ones. Some people say, why don't more people set up an MAPT? Look at that nice 3-generational picture there. Well, actually, a lot of people set them up. You just don't know about it because people don't generally run around broadcasting, hey, we set up a Medicaid Asset Protection Trust. You wouldn't know. But sometimes people, well, first of all, a lot of people never heard of it. Obviously, you haven't heard of it, you can't do it. But so many people get the wrong advice from well-meaning but uninformed friends, relatives, neighbors, and professionals. Why do I put professionals in quotes? Because on a fairly regular basis, clients will come into the office and say, my accountant told me, or my financial advisor told me. And the way they're speaking, it's as if they got a professional opinion. You know, it sounds like gospel. But actually, I have to explain to them, you didn't get a professional opinion. You got a personal opinion coming out of a professional's mouth. Now, accountants and financial advisors have their expertise, but this is certainly not one of them. And they often are well-meaning, but they give incorrect advice. I would say more often they give incorrect advice than correct advice because they don't know about the Medicaid trust. They don't know how it works. They don't know about trust generally. They're not trained in it. But also they never filed for Medicaid. So imagine this. Here at Ettinger Law Firm, we have filed over 4,000 Medicaid cases. People are getting the advice from an accountant or a financial advisor who hasn't filed one Medicaid case, doesn't know anything about it. They may have read something, may have heard something, they may have got a piece of advice, but they don't have comprehensive knowledge. So let's look at another issue here, long-term care insurance. What about long-term care insurance versus setting up a Medicaid Asset Protection Trust? Well, long-term care insurance protects your assets from a nursing home. Cost of care, maybe $15,000 to $21,000, $500 to $700 a day. That's about right. The reason you don't need long-term care insurance, well, first of all, some people say, well, it takes 5 years. Can I get long-term care insurance for the 5 years? And I say no, because the chance of your needing it in the next 5 years is very unlikely. You know, this is for a much longer time horizon. But how much insurance do you get? Well, you look at your income, because if you're in a nursing home, you still get your income. So if your income is $3,000 a month, well, let's say your income is $6,000 a month, and the nursing home is $16,000 a month. So you don't need to buy nursing home insurance for $16,000. You need $10,000 because you got $6,000 already. Now, some people have both long-term care insurance and the Medicaid Asset Protection Trust, and here's why. They want the long-term care insurance for home care. This might be $250 to $300 a day, about half the cost of care in a facility. So they want to be able to afford home care in their own home, but they don't want to pay the premium for a long-term care policy. So they get they don't want to pay the $600 premium. They're willing to pay for the $300 a day premium. So they get the long-term care insurance for home care, and they use MAPT to protect their assets in case they have to go into a facility. You can actually have both. Let's look at the do's and don'ts of these Medicaid Asset Protection Trusts. So, and all this is in my book. I wrote the book on elder law estate planning. It's called Elder Law Estate Planning. It's by me. We give you a free copy when you come into the office, or we can email you a copy of the book if you like. So the do's and don'ts: do make all transfers to your trust that we advise you in a timely manner, because you want to start the 5 years. Do use the trust assets. You can use any money in the trust for repairs to the house, maintenance on the house, and improvements to the house, and also for homeowners insurance. Because the house is in the trust, you can use the money in the trust for the house. That's not taking it out. You can pay real estate taxes, homeowners insurance. And by the way, this is permissive. You can use the trust or pay it from outside the trust. However, your individual tax deduction is lost if the trust pays the real estate taxes. So you may want to pay those individually. There is a chance that the deduction for state and for state, the SALT, this property and state income tax deduction will come back, the SALT, under the Biden administration. Do take your dividends and income on the trust assets on at least a quarterly basis. If the end of the year comes and you haven't taken the income, it's the same as if you put the money in. So they consider this additional to principal, and it's a 5-year look back on the new money that you didn't take that year. Do contact the elder law firm when you wish to make a gift from the trust to any of your beneficiaries. You don't need our permission to make the gift, but we'll help you write the letter. It's a one-line letter. I hereby direct you, Jeannie, my trustee, to make a gift from my trust to yourself in the amount of $25,000 or whatever it is. The reason for the gifting letter is so that they can show their brothers and sisters they didn't just take the money for themselves, it was at your direction. Do contact the elder law firm if one of the persons set up the trust needs a Medicaid benefit, or when they die. We have to settle the trust, close it out. Medicaid we have to apply for. It's a considerable amount of paperwork to do that. Here's some of the don'ts. Don't use trust assets to pay personal expenses. Personal expenses are your cable bill, your cell phone bill, etc. Don't use the trust assets to buy a car. Let's say you buy a car in the name of the trust and you get into an accident. Now all the assets in the trust, which are protected from lawsuits and creditors, are available to the person who got injured by the car because the car is in the trust. So we always keep the car outside the trust. Don't use trust assets to pay telephone, utility bills. I mentioned that. Don't take principal or capital gains. So if you have, you can't take principal, we know that, but if you have capital gains, that's in addition to principal, you can't take your capital gains. If you need it, make a gift out to your son or daughter. Again, they can't give it back to you, but they can spend it on you. Don't transfer IRAs or 401ks to the trust. First of all, that's a taxable event. All the taxes will be due, and it's not necessary. They are exempt from Medicaid. They're also exempt from probate. IRAs, 401ks, and the like have a designated beneficiary. It goes right to the person's name. There's no reason to put it into the trust. Don't allow your beneficiaries to return to the trust or to you any gifts made from the trust assets. That's an absolute no-no, because remember, you can't get principal, either directly or indirectly. Don't make additional transfers to the trust without advising us. Just let us know so we can track the penalty period. So where do we go from here? Well, in a moment, I'm going to invite you for a free consultation. We have our seminar tomorrow, the 4 reasons why trusts protect you better than wills. There I'm talking about revocable versus irrevocable trust, inheritance protection trust, and a little bit about the Medicaid Asset Protection Trust and elder law power of attorney, a few other things. You do that you just go to ettingerplan.com. It's not case sensitive, put it in any way you like, and you'll be invited to register there. Wednesdays at 2, but if you can't make it, if you can't make it, you just register anyway, and we'll send you the recording. One moment. Okay, let's move on. And now a word about our unique planning process, already begun with this seminar. We offer a free initial consultation. We also do a free review of your existing plan if you have one. You bring in your will, trust, power of attorney, whatnot. We tell you if it's legally adequate. If not, we'll explain why. And we'll see if those are still the people you want and the percentages you want for legal, medical, and financial. As I mentioned, you get a free copy of my book, Elder Law Estate Planning. We'll tell you which chapters applies to your situation. And it might be an hour and change worth of reading, but it'll be worthwhile. Once we have your situation analyzed, we'll give you a fixed fee quote. It's not based on how much you have, it's based on what you need, if anything. But we don't do business on the first meeting. We give you the number because people want to know what they're in for. But we generally will set up a second free follow-up consultation to give you a chance to think about our recommendations and to have all your questions answered, especially on what you may have read in the book. So at the second free consultation, again, we answer any questions that you might have. We draft the estate plan together with you. And now we provide a detailed written proposal for the fees quoted. So this is a 3-page proposal. Here's what we're recommending. Here's what we're going to do. Here's the fees we mentioned last time. Now it's in writing. What would you like to do? And the choice, of course, to go ahead is yours. And now we break with tradition. I believe we're the only law firm in the country that does this. We do not use a retainer agreement like I was trained and every other lawyer was trained, which is you want to go ahead, here's our agreement, sign, give us a check to get started, usually for half the fee. It's called the retainer. We don't do that because we like to keep our clients in control. So what we do is something else. We have something called a fee proposal. We sign it, you don't sign it. Our fee proposal says on your say, so we're going to go ahead and prepare all the documents, trusts, inheritance trust, health proxy, living will, power of attorney, deed your properties to the trust. After everything is signed and done, you pay at the end. But our agreement says, unless and until you write us a check, you have no obligation to the firm. You're a free agent, get up and walk away anytime. Not that that happens, but rarely, but we like it because it puts the clients in control. And here's the great breakthrough that we feel we made in this area. We feel that if you're in control during the whole process, which you are, obviously that's the best place for you to be. And if you're the client and we're here to serve you, and that's the best place for you to be, we feel it's the best place for us to be. And it's worked very well. We now have over 30,000 satisfied clients. So you come in 2 or 3 weeks after this, you're in your third meeting, we review all the documents, everything meets your satisfaction, you sign, and then you can pay by credit card or check. You can pay it all at once, you can pay it over 3 monthly installments. Now, even at the best of firms, this is generally the end of it. They say, thank you very much for your patronage and goodbye. I'm sure nobody, whoever did a will, heard from the lawyer who did the will. There's no system for that. It's not the way it's done. But we found that not to work very well, and we think it's a defective system. It's antiquated. You know, the pace of change today is 100 times what it was 50, even 60 years ago. So we don't say goodbye, we say welcome to the firm. And let me just take a step back. The reason we track these plans for law changes and all the other features we have is because we actually care that the plan works when you need it, not when you wrote it. I hope it's decades later, but who says it's going to work when you need it? Actually, it probably won't, considering the pace of change today. I didn't want as my legacy. Ettinger created 30,000 plans that didn't work. So I want my plans to work. I care that they work. So we trademarked the process in '99, so it's 22 years ago. It's called the Ettinger Elder Law Estate Planning Process. It's trademarked in Washington. It's designed to make an Ettinger plan work when you need it, not when you wrote it. So we keep you up to date for law changes and other matters through our weekly Ettinger Elder alert. We call it an alert because it comes by email. And we won an award for it, actually. It's 1 article a week. Every 2 years, this year being a notable exception, we invite our clients to breakfast, update you on the law, what's happening in the law firm. We invite your next of kin to meet the lawyers. But the key is this. Every 3 years, we send you a letter. Time to come in for your free review. Why do you want to see every 3 years? We have no other way of knowing. Did your health change, your assets, your family, births, deaths, marriage, divorces? So come in after 3 years. Not too many people need to change, but we catch up with each other, get around, we renew the acquaintance. It's valuable. We want to build that relationship. Let's go back a slide. So after 6 years, naturally, second more people need to change. But the reason we do it, statistically, it's been shown that very few people will get past 9 or 12 years without needing a major change. Who's in charge, who they're leaving to, something else happened. So now you need to do an amendment. Amendments average about once every 10 years. We're talking, now that's legal work, you have to pay for it, but we're talking hundreds, not thousands, you're good to go. The point is, when you go to use an Ettinger plan, it's designed to work when you need it, not when you wrote it. We don't charge for phone calls or emails or questions. We want to hear from you. That's why we don't charge. We don't want people to be afraid to let us know or ask a question. So we don't charge for that. But by using this program, your plan is never more than 3 years old, designed to work when you need it, not when you signed it, as I said, I hope many decades earlier. We have saved thousands of people, countless thousands of problems, and it has a nice side effect, which when something bad happens to one of our clients, we know who it is because we have the review every 3 years, and we have the breakfast every couple of years, seeing the average client 9 or 10 times. So I recommend that highly to you. It makes a huge difference when something happens. So if you'd like a free consultation with myself or Mrs. Ettinger, or one of our experienced elder law attorneys, everybody is trained the same way. It can be in the office, it can be by Zoom, like today, or by phone. You're going to get an invitation tomorrow from our Calendly link. They'll send you the link and you can pick a time that's convenient to you. You'll get that tomorrow with a copy of this Zoom presentation. You can call my firm Director of Client Relations, Patty Brown, been with us, it's her 26th anniversary. So we'll wish her a happy anniversary. She can answer any questions you have. She's been here for 26 years. She's at 800-500-2525, extension 117. That's Patty Brown. You can email her, pbrown@trustlaw.com, or if you like, text free C, that's free consultation, but use the abbreviation free C to the number on your screen. So now we're going to go, we're going to shrink this. We'll go back to the Zoom. We're going to stop the share. Here I am. We have some questions. So let's see. Sandra S. says, is it better to have a will and trust? Well, yes, Sandra. Whenever we prepare a trust, any lawyer prepares a trust, also prepares something called a pour-over will, P-O-U-R. It cancels the old will. Later will, as a matter of law, cancels an earlier will. And it also says, in case I left something out of the trust, pour it in there after I'm gone because my wishes are written in the trust. You know, we don't want to have to use that pour-over will because it'd have to probate for that asset, but we like to have it just in case. Anonymous says, is a Roth IRA considered a qualified plan? Well, yes, Anonymous, a Roth is a qualified plan, but if you have to go into nursing home, you have to start taking it out according to Medicaid's. Medicaid has their own schedule for how much you have to draw each year. It's a little faster than the IRA rules, but you have to start taking. And if you have to start taking, then they can only get the distribution you're taking. That can't go into the plan itself. Linda B says, what if you sell your house in New York but buy a condo in a different state? There's no problem with that whatsoever. You can do that. Once you have your Medicaid trust, it's recognized in Florida and South Carolina. Those are the places you asked about. Marlene B. Hi, Marlene. Nice to touch base with you. Marlene B. is a friend of mine for decades now. She's there with her spouse. And if you'd like to see us, Marlene, give us a call. And hopefully, if you want to see me personally, you'd have to come to White Plains. I'm there every couple of weeks. So I live on Long Island now. So yes, call and make an appointment. And it should be with me. We go back a long time. I'll ask you to drive to the White Plains office. Or if I have time, I'll drive out to Rockland and see you there. Next question. By the way, we're moving our Rockland office from Nyack to New City. You'll get an email about that. Debbie M., please email me a copy of the estate planning book. If you want a copy of the book, you have to send an email, Debbie, to pbrown. It was on the slide before, pbrown@trustlaw.com. Pat will be happy to send you a copy of my book by email. Carol L., Medicaid income limit is, a certain amount for a single person. How do all of us listening to this, who I assume will have monetary and physical assets well into 6 figures, qualify for Medicaid even after we move all the non-qualified assets into the MAPT? Yes, you do have to take the income. If your Social Security, your pension, your investment is more than $20,000 a month in income, then you can't get Medicaid. That is a problem. Medicaid is for people, most people don't have $20,000 a month in income. If you have $20,000 a month in income, that is the cost of care. So protecting your assets is not really a viable option. You'll be paying out of your pocket. If you have that much income and you're possibly insurable, you need to look at long-term care insurance to pay for that so you can keep your income. If it's home care, there's rules to shelter the income. So that's another subject. But there's a chapter in my book on getting home care with the pooled income trust. So we'll talk about that. Teresa P. says, what happens to the principal left in the MAP upon death? Good question, Teresa. Just like any trust on death, it goes to the named heirs, or like any will, according to the terms of the trust, whatever you want. It can go to inheritance protection trust for them, or it can go to them outright. Anonymous, are IRAs exempted from paying nursing home costs in every state, only in New York State? Actually, they're not. It's not exempt in New Jersey. So there you go. I don't know about every state, but I know in New Jersey, the IRAs are available for the cost of care. Joe, J-O, female, G says, What if you have no heirs or spouse? Is it worth having a trust? That's a good question, Joe. If you don't have heirs or a spouse, you probably don't need a Medicaid Asset Protection Trust, because generally the position is, well, look, if I need it for myself, I'll spend it, and whoever gets it after I'm gone, it's up I'm not going to worry about protecting it for them. I'll use it for me if I need it. You do need a revocable trust, Joe. Maybe you want to tie into my seminar tomorrow at 2 o'clock at ettingerplan.com, because if you have no heirs or spouse and you become disabled, you're a great risk for guardianship proceedings. You don't want the state to step in and appoint a stranger to handle your affairs. So you set up a revocable trust, you put yourself in charge, and the trust says if your doctor determines you're unable to handle your legal and financial affairs, the people you pick, your hand-picked people are in charge, not the state of New York. And you pick one person, you can pick two people to act together. If you don't have someone, you can pick your elder law attorney. Lots of options. You should come in and talk about it. People are raising their hands again. Go ahead. If you're raising your hand, then type in your question. I'll answer it at the end. Anonymous. Is a gift of principal for the trust limited to $15,000 per person per year? No. A lot of people don't know this, but you can give over the $15,000. You just have to report the gift, but there's no tax, because if you give more than $15,000, they take it off the amount you're allowed to give at death. Under the Trump rules, which are still in effect, you can give $11.5 million when you die. So you give over $15,000, you report it to the IRS, they take it off your $11.5 million when you die. Not a problem. Might go down to $6 million under the Biden administration. Not a problem. Report the gift. You're never going to get to the $6 million. Not a problem. Have to report the gift. There's no tax. Joseph M. says, is the transfer of a non-qualified annuity taxable? Yes, because Joe, if there's cash value in that non-qualified, non-IRA type of annuity, and you transfer it, it's a taxable event. So you owe taxes on any income that it earned. But we can put in the trust without triggering a taxable event, because the trust is still you for tax purposes. You won't have to pay that tax. Anonymous. What is the difference between a Medicaid trust and an irrevocable trust not named as a Medicaid trust? Well, Anonymous, there are probably 100 different types of irrevocable trust. The Medicaid trust is one of them, and there's many others for many other purposes. Ours is, a lot of them are done to get assets out of your name for tax purposes. Ours are not. Ours is designed to get it out of your name for Medicaid purposes. Still in your name for tax purposes. You pay the same income taxes before. Sandra S. How come I was never invited for a review of my trust? It was done in 2014. I'm not sure, Sandra. It might have gone to you and you might have missed it, or who knows. Of course, you're very welcome to come in. So Sandra, contact Patty Brown and schedule your free review. Carol L. Oh, the 20,000 in income meant as per year, not monthly. Oh, no. So your income is much less than the cost of care, so no problem. You'll be eligible for Medicaid. No, you're confusing income and assets. You're allowed to keep up to, if you have a spouse, the spouse can keep about $3,000 a month of the combined income. If you're single, all your income goes to the cost of care. And then the asset limits, maybe up to $130,000 if you have a spouse. The spouse at home can keep up to $130,000. If you're single, you can only keep about $16,000 in assets. If you have more than that, you have to spend it down before you're eligible for Medicaid, unless you sheltered it out with that trust a few years before. Mara F says, you mentioned $20,000 income for Medicaid eligibility. What if Social Security income is over $30,000? Well, we're getting confused between per year and per month. If it's per year, it's only about $30,000 or $36,000, $3,000 a month. No problem. You'll be eligible for Medicaid, and we can shelter that money if you need home care. If it's facility care, different rules if you have a spouse or you're single. Anybody else have any questions? Now is the time to type them in. But I want to thank you for joining me, and please join me next week for the next installment in our 6-part series. And if you like, sign up at ettingerplan.com. I'll see you tomorrow at 2 o'clock. I want to thank you for joining. Thank you for staying in, staying safe. Wish you all the best. And hopefully in a few months, we'll be through all of this COVID and on to bigger and better things. So let me wish you all well. and look forward to seeing you again next week. Thank you for joining and have a nice afternoon.